Good morning, sir. My name is Miss Harshala Jawahar Srivastu. My roll number is 151. I am learning in LLB third year. My today's topic is origin and primary sources of international law, including customary rules. Introduction. International law is comprehensive in nature, and due to that, it is an amalgamation of various sources. There exists no single system of law which can interpret and extend the law, but an international law still exists and is ascertainable. There are sources available from which the rule of international law may be extracted and analyzed. According to Lawrence, if we take the source of law which has all the authority required to give it binding force, then in respect of international law, there is one source of law, and that is the consent of nation. This consent may be either tacit or expressed. Major sources which form the conventional source of international law includes the International Convention and treaties. Sources of international law can be bifurcate into primary and secondary sources which are explained below. Primary sources. Primary sources of international law are considered formal in nature. They came from official bodies which include treaties, customs, and principles of law. Article 31 1A(c) of the C statute is widely recognized as the backbone of the formal source of international law. It is generally regarded as an authoritative statement of the sources of international law. Article 38 of the statute of the International Court of Justice in The Hague has been treated as a convenient catalogue of international legal sources. Article 38 of the ICJ Statute. Article 38 1AC of the ICJ was adopted by the same provision of the Statute of Permanent Court of International Justice, which operated under the auspices support of League of Nations in 1920. The article refers to the primary sources of international law which are enumerated below. Custom as a source of international law. Original and the oldest source of law is known as custom. The rule of customary international law is a long historical process which gained recognition by the entire community. The presence of customary rules can be deduced from state practice and behavior because it is not a written source of law. A rule of customary law is said to have two elements. First, there must be widespread and consistent state practices. Secondly, there has to be opinio juris, a Latin term which means a legal obligations to believe in the existence of such law. Now, features of customary law: uniform and general. State practices to give rise to binding rules. Customary international law. That practice must be uniform, consistent in general, and must be coupled with a belief that the practice is obligatory rather than habitual. In the asylum case, the court declared that the customary rule must be used constantly and uniformly throughout history, which can be traced through the state practices. Duration. Court continuous and regular use of particular conduct is considered as a rule of customary law. In the North Sea continental shelf cases, the ICJ stated that there is no practice length of time during which the practice must exist. It is simply that it must be followed long enough to show that other requirements of customs are satisfactory throughout. Then an opinion of law to assume the statute to assume the status of customary international law, the rule of question must be regarded by the state as binding of law. That is, states must regard themselves being under a legal obligation to follow the practices. In the in the Lotus case, opinio juris was seen as an essential element of customary international law, and this was affirmed in North Sea continental shelf case as well. Convention as a source of international law. Treaties and conventions are one of the most important sources of international law. These conventions can be multilateral or bilateral. Multilateral conventions relate to the treaties which formulate the universal of or general application of the law. On the other hand, bilateral conventions are those which is formed exclusively by two states to deal with a particular matter concerning these states. General principle of international law. Some of the examples of general principle includes the rule of res judicata, which has been affirmed by the court in case of genocide conventions Bosnia and Herzegovina versus Serbia and Montenegro. The rule of pacta sunt servanda made applicable. Reparation must be made for damages caused by the fault. The right of self defense for the individual against attack on his person, family, or community against a clear and present danger. For one's own cause, no one can be judged, and that the judge must hear both the sides. Here I have finished my topic. Thank you.